Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Berg versus Wiley. This case was heard in the Supreme Court of Minnesota in the year of 1978. Let's go ahead and jump into the facts of the case. Berg is the plaintiff. Berg was a tenant. The defendant is the landlord, Wiley, in this case. Wiley originally leased his property to Philip Berg. Philip Berg used this property as a pool hall, a drinking hall, kind of a social space. Philip Berg didn't really like using the property for this, so he assigned his lease with the consent of Wiley to Kathleen, his sister. Kathleen was going to take over this property and make it a restaurant. So when this assignment goes on, there's some terms that are in the lease that become important. The first term is that if someone uses it as a restaurant, so if Kathleen Berg uses this as a restaurant, she has to do it in a lawful manner. So that would mean obeying health code regulations. And then two, if she changes anything about the property materially, something like knocking out a wall, having to put more plumbing in, more electric in, she needs to let Wiley know before she does that. So material changes to the property. So in the course of Berg's remodeling, she does make some material changes. She doesn't disclose this to Wiley. Wiley's frustrated. She does operate the restaurant and it breaks health code regulations. So she wasn't really doing it in a lawful manner. It's pretty easy to see that Berg was breaching the lease agreement, the contract in this case. And so Wiley sent Berg a letter, said, hey, you have 2 weeks to clean up your act, essentially. And if you don't, then we're taking the property back. Berg continued to operate the restaurant for 2 weeks. And then on the 14th day, so the last day of the time period, Berg puts a sign on the wall, says closed for remodeling. She fires all her employees. And she essentially leaves for that day, locking it up, right? Wiley is there that night, and there's a little bit of violence that ensues between the two parties. Nothing physical, but a shouting match. It wasn't peaceful. Wiley wanted to take his property back. Berg didn't really want to leave it. You can imagine emotions are flaring between these two parties. So Wiley comes back the next day when Berg isn't there, sneaks in, changes the locks, and basically locks Berg out. His attorney advised him to do this, so he felt like it was a good idea to go change the locks, lock Berg out, but Berg can't get back into the space, which was the restaurant. She can't get her property out. So Berg sues for wrongful eviction. She says that what Wiley did by changing the locks was wrongful eviction. Wiley defends himself. Wiley says that one, Berg abandoned the property when she didn't, when she didn't live up to her end of the agreement that was set forth in the lease, and then she didn't fix the things in the 2 weeks, and she left and put that sign up. She fired her employees. She abandoned the property. So the court grapples with this, and they do so pretty quickly. They say it's pretty obvious Berg didn't intend to abandon the property. So the second defense that Wiley puts up, and this is the important one, is Wiley says he has some ground to use self-help techniques to retake possession of his property when a tenant has breached the lease agreement. So Wiley, the court says, well, we do recognize some self-help to retake the property, but one, we have to be 100% sure that the landlord has a legal possession of the property at that point in time. And then two, we have to be 100% sure that what the landlord did was peaceable. So the court focuses large on this peaceful right of reentry, a peaceful reentry of the landlord when the tenant breaches the condition. So the court says what Wiley did was not peaceful. When Wiley came in and snuck in, changed the locks, when he had a shouting match, when the police were called that night, that wasn't a peaceful experience. So Wiley's self-help isn't justified. Wiley's self-help is not going to hold up as a defense, and they allow Berg to recover for wrongful eviction. They affirm the ruling in the trial court and say that that was a wrongful eviction. And they've set forth a new rule that says if self-help techniques really aren't justified in any way by landlords, they all need to go through the judicial process if they're going to try and get a tenant evicted from the property. So that's the case. The ex ante discussion of the case, and definitely what the court was thinking when they were considering these facts, was how do you balance the property rights of a landlord with a peaceful society, right? So in this case, it's pretty obvious that Berg had breached the terms of her lease agreement. It's pretty obvious that Wiley had a right of reentry. Wiley didn't do this peacefully. So where do we draw that line, right? Like if Wiley's forced to do this in a peaceful manner, can't Berg just kind of sit there, arms folded, and say, hey, you can't live, I'm not leaving, right? And then what is Wiley going to do to get her to leave in a peaceful way? Well, he can't. So it doesn't really reify and respect the landlord's rights to property. What this ruling does do is it respects the rights of the tenant, It respects the rights of the tenant to a peaceful transition out of their property if they can't pay rent, if they breach a condition in the lease agreement. It's saying, hey, landlord, you can't go in there guns a-blazing, change the locks, go crazy. If the tenant is going to get evicted, it's going to be through the judicial process. And we're going to maintain law and order when we do this. And it's not just the wild, wild west. You're going to reclaim your property. So, but it is an interesting discussion to have, is should the landlord have enough rights to go and retake that property if someone's not leaving, right? Because it is a lot of money, it's a lot of expense for a landlord to have to go through the judicial process to get that tenant evicted. Whereas if they could just go in the night and change the locks and then the tenant can't get back in, maybe that's a little bit more efficient. Maybe we use less judicial resources that way. So something to think about. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a great rest of your day. Bye-bye.